Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video. Today I want to talk about single-member LLCs and what happens when the sole owner of the LLC dies, and what you should do if you are the owner of a single-member LLC in Tennessee to take into account the issues that might arise upon your death in order to preserve your business for your family. And so here's the situation. Let's say that one man or one woman owns a single-member LLC. That person is the sole owner, has all the economic interest in the LLC and also all the governance interest in the LLC. If that person dies, what happens to the LLC? Well, under the Tennessee statute, the Revised Limited Liability Company Act, an event that results in there being no members in the LLC, which would occur upon the death of the sole member, typically would require the dissolution of the LLC. But there's an exception to that rule with respect to the death of a single member in a single member LLC. The rule is, under the statute, if a sole member of an LLC dies and if the operating agreement of the entity does not require the dissolution of the LLC, and if the personal representative of the deceased sole member doesn't file a notice of dissolution of the LLC, that the LLC will continue after the death of the sole member, and the personal representative of the sole member is automatically substituted as the member of the LLC in place of the deceased member, effective as of the date of the deceased member's death. So, to summarize, if you have a sole member LLC and the sole member dies, and if the operating agreement is either silent as to what happens upon the death of the sole member, or it does not require the dissolution of the LLC upon the death of the sole member, then the LLC will continue with the personal representative, in other words, the executor of the estate of the sole member, becoming automatically substituted as the member of the LLC, effective as of the date of death of the sole member. Now, this can still be an issue for a company. You may not wish to have your personal representative become the sole member of your LLC upon your death. And in addition, it sometimes takes a bit of time for the person whom you name as executor of your estate to become the executor of your estate, to be appointed executor by the probate court. And so even though the membership interest of the personal representative would relate back to your date of death, there's a period of time after death and before the probate court appoints the executor that things are a little bit in limbo, because the personal representative hasn't been appointed. Who's the member? There is no member. Who runs the company? It's unclear and uncertain, and you don't want lack of clarity or uncertainty with respect to the operation of your business after you die. So what can you do to avoid that issue? Number one, the main thing you can do is to provide in your operating agreement for your LLC what happens when you die if you're the sole member. Who becomes a member? Who becomes the manager? Who runs the LLC? You need to be clear in your operating agreement as to what happens upon your death. You may want to go ahead and say that a particular family member or particular family members, plural, become members of the LLC automatically in your place upon your death, and give them the right not only to the economic interest in the LLC but also the governance rights in the LLC. Or you may want to appoint someone or some group of people to govern or to have the governance rights in the LLC at your death and give the economic interest in the business to other people. You may have family members that you want to share in the economic rights in the company, but you don't want them involved in the day-to-day running of the business. But the main thing is you need to be clear in your operating agreement what happens to the governance rights and to the economic rights of your business when you die. Otherwise, you're going to have this situation where after your death, but before your executor is appointed, there is a period of time when no one is running the show and no one is really in your place as the member of the business. Even though the executor under the statute would automatically become a member effective as of your death, there is a period of time after death but before appointment of the executor when no one is there to act on behalf of the company. And it may be that you really don't want your executor to be running the show for your company anyway. So the key takeaway is if you run a small business and you're the sole owner, make it clear, make it crystal clear in your operating agreement what happens upon your death. Name people, a person or people that would be your beneficiaries or whomever to step in as automatic members upon your death. Make sure if you want them to run the show that it's clear that they have not only the economic interest but the governance rights. And if you want to split the governance rights from the economic interest, make clear who you want to govern or have the governance rights in your LLC upon your death apart from the economic interest. It's very important that you take a close look at your operating agreement if you're a sole member LLC before your death so that there's not a problem created after your death with your LLC. All right, I hope that helps, and we'll see you next time.